Good morning, Mr. Voss.
Good morning.
Welcome.
Thank you.
And please be seated. When you're ready, you may begin with your opening statement.
Well, thank you. It's an opportunity to be here, and I appreciate the work that the Commission has done. In my visits with various ones of you, I've invariably found that you've been well prepared and have put in the time. And that is what I think makes this a good process. The fact that you've worked hard and done your due diligence and are continuing to do so. I was sitting in my house on Saturday afternoon trying to figure out what I was going to say today. And my little girl came up. She's turned 6 later this month. And she said, "What are you doing, Daddy?" And I said, "Well, I'm writing a short speech for Monday." And she looked at my notepad, and I had maybe 6 sentences on it. And then she looks back up at me and she says, "That's a good speech, Dad." So it's always nice to have the unqualified support of someone, even if they don't have a vote in this process. But last March, I sat in this chair talking with most of you, not all of you, but with most of you. And I shared the story of my father just as an example of what has motivated and driven me. My father was a lawyer. He passed away when he was 33 and when I was 6. And so I didn't know him as a practitioner, but I knew him by the stories that clients of his would tell me about the impact that he had had on them just by giving advice or walking through difficult situations with them. And so as I grew up, this was the only profession I had ever seriously considered. This was what I wanted to do. I had seen the impact that you could have on people when they were walking through sometimes the most difficult parts of their life. And that was what I wanted to do. And so that has been my motivation as a lawyer. And I wanted to start with that again because that's kind of the overarching driving force behind me. But I wanted to talk a little bit about a couple of different things. I think as you sit here, the questions you are asking and trying to determine are, what sort of person would this be as a judge? What would they have as in terms of work ethic? What would they have in terms of temperament and ability to work with other people? And then do they have the ability to get the law right? I think those are the questions that you're asking and trying to answer. So I wanted to talk just a little bit about who I am in those contexts. After my dad died, my mom was responsible for raising 4 kids, and she was determined that we would know how to work. And so I started in grade school delivering the Newton Daily News. I started detasseling corn when I was 14 years old and did 4 summers of that. In college, I did 4 summers working for a company called Longdon's Transfer. They were agents for Allied Van Lines and Kraus Cartage Corporation. And so when I walked in for that job interview, they looked at me, and I was, just done with my freshman year of college, and I was 160 pounds. And they gave me the job thinking that I would last one move, And I spent 4 summers with them and learned a lot there just in terms of how you treat people and how you treat work. That no matter what job you are doing, there is dignity in working hard. You have a chance to do any job that you are given either poorly or do it well. And some days the incentive wasn't real strong to do your job well because you would finish a household move and then your reward was to go work on the dock loading the east and westbound trailers. And so the reward for work was more work. And so at least once a week, my boss would look at me and say, "Well, that will make you go and study hard." And it did, But I learned the importance of working hard and the importance of being motivated not by external things, but by just your own sense of being a professional and taking pride in the way you go about things. And so I learned that the ability to work, I think, at an early age, and I think that's been a theme when I've been asked questions by the commissioners is, are you ready and able to handle the workload that the Court of Appeals presents? And I recognize that this is the workhorse court, if you will, just in terms of the number of cases that they process. And I think that's something that's been instilled in me a long time. I'm ready and willing to go to work and work hard. The next question a number of commissioners I think have asked directly and indirectly is, will you display a judicial temperament, and what qualities do you have there, personally, interpersonally, that will make you a good fit there? And I think that's probably demonstrated better than anything by the fact that I have had one secretary and one paralegal for the entire 17 years that I practiced. When you treat people with respect, when you are consistent with them, when you're respectful of their time, when you're respectful and appreciate the good things that they do, those qualities make for stability. Those qualities make for sustained relationships. And so I think in that area, I know how to work with people. I know how to get along and appreciate the contributions of others. And so those are things that you're taught long before you go through law school. And that character is something important that you take with you into the professional place, into the workplace, and that's something that I feel like I have and can demonstrate that by my history at the Heidman Law Firm. I think kind of the third question, and maybe the most important one, is, do you have the ability to do the job? Do you have the intellectual horsepower to do the work? And will you get the law right? And in that respect, I think there's probably not a better training ground than the Heidman Law Firm has been for me. I've had the opportunity to do a pretty diverse areas of work, being what I consider a fairly typical transactional lawyer, but also having an appellate practice that's put me in front of appellate courts in 3 different states. That, in terms of how I would go about the work of being a Court of Appeals judge, I think the appellate work that I've done gives me an understanding of the needs of appellants and litigants in this process. I wanted to touch on, I think in particular, litigants need a thorough and a clear answer when they get to the appellate level. I can think of the two times where I've been most frustrated with the appellate process was when I felt like, as a litigant, the procedure was unfair. And the first was a case where the merits of the case were entirely avoided, and the case ended up getting tossed on a procedural ground. It was prior to the amendment of Rule 1.904, and the court decided that the 1.904 motion that had been filed by a different firm before we got involved didn't toll the running of the 30 days for filing your notice of appeal, and so we never got to the merits of it. And the second time I felt that the litigation, the appellate process hadn't been fair, was we had a certified question that went to the Iowa Supreme Court, and only 6 of the justices ended up sitting for it, so it ended up being a 3-3 split, and they declined to answer the questions. And there may not be a more frustrating experience than going back to your client and saying, well, you paid for this briefing, we went and argued it, and nothing got answered. And so as it pertains to the work of being an appellate judge, I recognize the importance of providing clear answers, answering all of the questions that are fairly in front of you, and just according respect to the litigants in the process as well. I think that as far as intellectual ability and ability to process the work of the case, the work of the Court of Appeals, my written record in terms of the application and writing samples probably demonstrate that well enough. But I wanted to talk more about how I would approach it and the attitude of what I think is important for a judge. So with that, I guess if there's any questions that you have for me.
Great. Thank you, Mr. Voss. And we'll start with Mr. Horbach.
I have no questions. Thank you.
Mr. Bevel?
No questions.
Mrs. Sinclair?
No questions.
Ms. Valentine?
Thank you. Mr. Voss, I'm curious as to your thoughts on handling criminal matters on appeal, knowing that that's a large part of the Court of Appeals work, and knowing that that's not really an area that you've had much experience in.
Sure. And that's a fair question. I think the law is big enough that no one would come onto the bench with great depth in every single area of it. I recognize that is an area where I have less experience. One of the things that's perhaps unique about being at the appellate level compared to a lower level court is that the issues come at you with a little bit of a different speed. You have the time to research and evaluate, and so that's an area where I would anticipate, doing some extra study and getting up to speed early on in my career. I know I can do that, but certainly it is an area where I recognize that I don't have currently a lot of experience in that area. So it would be just an issue of putting in the study and the work to get up to speed, if you will, in that area.
Thank you.
Mr. Berger? Ms. Stanger?
Thank you. Good morning.
Good morning.
Mr. Voss, one of the themes we've heard or flags we've heard is that there's some value in having district court experience or district associate court experience, or at least a significant amount of trial experience. And you're a great one to ask this question to, because you have a tremendous amount of appellate experience, but not that trial experience. What is it that you bring to the appellate court that maybe from other experiences qualifies you at some of those same experiences that those district court judges had or district associate judges had? For example, you might think the district court judge is comfortable making decisions on less than perfect information, making hard decisions on a variety of areas of law. What is it that would maybe bring you on par with some of those experiences, which seem to be very valuable to commission members?
Sure. And serving well on the district court is a great ability, and I think a slightly different skill set than what the Court of Appeals requires in terms of, once again, the issues come at you at a different speed. I would not put myself as someone who would be a great district court judge because at this point in my career, the ability to rule quickly on evidentiary matters has not been something that's been part of my practice. But I think in terms of substantive ability and knowledge of the law, I feel like I have real strengths in that area. The litigation work that I've done has probably been what you would call litigation support, where I've done a lot of brief writing, unwinding some of the more difficult issues. I've worked on jury instructions with colleagues of mine at the firm, and so I know how those get put together and argued, and so I have litigation experience more than I have courtroom experience in terms of knowing and understanding what the process is like and what it requires. And so I do think that I have the necessary skill set, even though I'm not a district court judge.
Thank you.
Ms. Pearson.
No questions.
Mr. Gray. Ms. Law.
No questions.
Mr. Goodman.
Mr. Voss, one of the best compliments a judge can receive is a person who lets lawyers try their case and not get in the way, but simply call balls and strikes. Another one is someone who's been a plaintiff's lawyer or a criminal defense lawyer 5 years onto the bench. You can't tell what they did before they were on the bench, meaning they might sentence people to prison even though they were arguing for leniency as a criminal defense lawyer, or they prosecuted 100% plaintiff's cases as a lawyer, and now they're put in charge of being fair to the defense. Is there a judge that you look to in the history of Iowa that has a transactional background that you think he or she has brought something to the bench that did not exist there before that you would emulate?
I'm not, and perhaps there's more history that I should know that I don't. Certainly the current path to the courts is not necessarily a transactional one. It's not a common route, and so I think if you look back, several generations, there was a sense in which lawyers were much more generalists than we are today, and so I can't give you a specific judge that I say this is who was my transactional hero, but your first comment in terms of one of the best compliments that a judge can receive is that it's not clear where they came from in terms of there's no discernible bias one way or the other is a very important observation. And I think coming from the Heidman Law Firm, we certainly historically were known as a insurance defense firm, but as we've developed in the time that I've been here, I've worked on plaintiffs' cases, I've worked on defense cases, I've worked on transactional matters. And so I've seen, regardless of who your client is, the thing that you want in a judge is you want the confidence that you are being judged on the individual merits of your case rather than the characteristics that you bring or the side of the V that you are on. And so that is very important to me.
Mr. Sukup.
None, thank you.
Ms. O'Brien.
Thank you. Mr. Voss, your litigation and appeal experience seems to be focused more on the civil side, as you noted. And as we look at the docket for the Court of Appeals, of course, it's a lot of juvenile, it's a lot of criminal, it's a lot of family law. And my concern is the overwhelming social issues that are sort of, not necessarily do you know the elements of what it takes to do child custody, but just the social framework and the social problems that are sort of part and parcel of the Court of Appeals docket. Have you given any thought to your perspective on those issues?
Sure. One of my partners, Roz Kobe, does the vast majority of our family law work at the firm, and I've written several appeals for her, and I was always the one that she would come to in the context of a divorce saying, here's the tax returns, can you make sense of them and tell me what number I should be putting on the the child support calculations. And so it's, again, it's not completely foreign. It's not been a high volume of what I've done, but I have some familiarity with that process. And what I think, in family law cases, of course, you are, particularly as it pertains to children, the standard is what's in the best interest of the child. And I think that has to be a very fact-intensive inquiry, because every situation is unique. That's why the court is sitting in equity with the opportunity to look at the record de novo. And as we look at that, I think that the statutory structure that exists, for good reason, makes every effort to preserve the family structure where that's possible. And sitting at the Court of Appeals level, I think that you are at that point in the process where you realize that generally every effort at reunification has been made and followed. And so I would, I would not be bound to give deference to the decision that's been made below. I certainly would respect that to get all the way through, the process to this point where there's been a termination of parental rights or some other permanent status change that's on appeal. There's a lot of gravity and a lot of weight to the process that's happened so far. I would make sure that procedural steps have been followed. I would, as a practical matter, give a degree of deference to the decision that's been made by the people in the trenches who see it every day.
Thank you, and we are out of time for today. Thank you, Mr. Voss, for being here, and we wish you well.
Thank you.
Thank you, Mr. Voss.